Good afternoon and welcome to the latest Lunch and Learn series. We're delighted you could join us today and thrilled to see such strong numbers attending. Just a brief introduction, my name is Salvador Nash and I'm the Director and Head of KPMG Legal Company Secretarial Services. We are part of KPMG's multidisciplinary service offering and we are the largest provider of company law and company secretarial services in the country. I'm also President of the Chartered Governance Institute and in my third and final year of that role. I represent the Institute as a member of the Company Law Review Group, and I'm also chair of that group's Corporate Governance Committee. Let me introduce our speakers today. Alan Browning is our first speaker, and he trained in Dublin prior to a move to London, where he spent several years working in the insurance industry. Following a return to Dublin, he headed up the company secretarial departments of two leading law firms, and we look forward to hearing his insights on governance of meetings during the pandemic. Sinead Humphreys will then give an overview of the COVID-19 Act and the new CRO system, which is designed to make it easier to file documents in the company's registration office. She will also highlight some changes to the filing requirements for certain unlimited companies. Sinead joined KPMG in 2012, completed her training with the firm in 2015, and was promoted to Associate Director in May 19. As part of her Masters, she received the Newton Compton Cup Award for Outstanding Academic Achievement in company law and corporate secretaryship. Governance of board meetings and working remotely. There is an expression that says you couldn't make it up, and I think it aptly reflects the fact that 12 months ago, no one could have predicted COVID or the impact it has had in the corporate context and in the wider community. The Institute, which is a regulatory body for those working in corporate governance, decided to carry out a survey of some of the challenges to corporate governance due to the COVID lockdown requirements. Its autumn survey of leading company and board secretaries in the listed private and public sector summarised how those changes have impacted boards. There were three main findings from that survey, and Alan will bring us through those findings. We will also share our own experience from clients and the experience of other members within our professional community. At the outset, could I suggest, and after 10 months or so of the pandemic, that the holding of meetings, whether it be board or general meetings, and their governance has changed utterly. And that statement is, to a certain extent, stating the obvious. Alan will also bring us through some frequently asked questions on annual general meetings and the changes for the period of the pandemic. This area was considered by the Corporate Governance Committee of the Company Law Review Group, and its recommendations to government were fully reflected in the company's miscellaneous provisions COVID Act of 2020. Just an observation, as chair of that committee and someone with 30 years experience, I've never seen such heated debate on the topic of annual general meetings. I'll hand you over to Alan in a moment. Before we get started, I'd like to go over a few housekeeping items so you know how to participate in today's event. At any time during the webinar, you'll have the opportunity to submit your questions. To do so, just type the questions into the Q&A section at the bottom of the control panel. And then as time allows, the presenters will address as many questions as they can during the Q&A sessions at the end of the presentations. We will be recording this webinar and sharing the link after the event. Finally, just to particularly welcome members of the Corporate Governance Association of Ireland who join us today, and thanks to both Declan Carew and James Kavanagh for facilitating. That's enough from me. I hope you enjoy the presentations, and I'll hand you over to Alan now.
Thank you, Sal, for that introduction. And again, welcome to our webinar today. As you know, the coronavirus arrived on our shores at the start of last year, and we were all forced into rethinking how we're going to work as we were forced to start working remotely. This also forced companies and their boards into rethinking their ways of working as they had to start working remotely, and this is now the norm. I'm going to kick off today's talk by sharing some of our insights and experiences of the governance of virtual board meetings, and follow that with questions that are being asked around AGMs in light of the impact of the pandemic. So moving on, through our position as the largest company secretarial practice in Ireland and our network of professional advisors, clients and other fellow company secretaries, we've gained a unique insight and seen firsthand how board meetings are working and are being run. and some of the principal challenges impacting companies and their boards and their AGMs. And I'd like to share some of those with you now. In terms of how companies are coping with virtual meetings, the impact, I suppose, of the pandemic was very sudden, and pretty much overnight companies had to adjust to that new reality of holding meetings virtually. Although I suppose companies were embracing that to a certain degree at before the pandemic, in that they were holding telephone meetings, they're now forced to embrace it on a full-time basis. So we're finding that on the whole, clients have coped quite well with the transition to virtual meetings, but there are challenges associated with that, and I think particularly around issues of debate and discussion at the board meeting. And also the dynamics of how a board meeting actually works. That opportunity to see how and read somebody's body language, see, you know, that they're, whether it's a shrug of the shoulders or a raise the eyebrows, they're missing. And missing also is that sort of feel and sense of what people are thinking. And really, we see there's no substitute for that face-to-face meeting. I think it would help in this regard by leaving cameras on during meetings so the chair gets more of a sense of what participants are thinking rather than looking at a blank screen of participants. I think all of us can see how working and holding meetings has changed and can understand some of those changes in dynamics. In terms of moderating meetings, one of the challenges we've come across is trying to stick to timings of meetings, as participants attending online tend to keep talking, and it can be difficult to intervene and move them on in their conversation. We found that if there is a dominant speaker, I suppose that free flow of discussion and conversation that you normally get at a physical meeting can generally be curtailed where meetings are held virtually. I mean, I recall myself when physical meetings were being held that a particular chairman used to take off his watch at the start of the meeting deliberately and place it on the table in front of him. And I suppose that was a symbol or a gesture to people who were presenting at that meeting, that they were on a timer and they were against the clock. So I suppose if meetings are running on for a few hours, it can be difficult to maintain focus at that meeting. And so maybe a suggestion there might be splitting the meeting in two by having maybe part of the meeting on one morning and then following the second part of the meeting on another morning. In terms of part physical, part virtual meetings, we found that where participants are dialing in and there are people physically present, that the persons dialing in don't really get to contribute as fully as the people who are physically in the room. People dialing in are more removed from the core group and the dynamics of what's happening in the room, and that sense and feel for what people are thinking. And sometimes they can even feel overlooked. So perhaps a suggestion or a help there may be to rotate your speakers where, you know, different directors are presenting at different times, at different meetings. In general, we found though that meetings really held entirely virtually work probably better than part physical and part virtual meetings. So moving on, in the regularity of meetings we feel has been increased. I think there was a demand at the start of the pandemic for more regular meetings and sharing of information. And if anything, I suppose boards feel now that they're more informed than ever before to some of the key governance, control and financial matters. And they're more aware of the risks posed to their companies because of that. Also at the outset of the pandemic, I suppose boards and their companies felt there were some issues around security. They didn't feel as comfortable with holding their meetings online because of the security issues. Really, the main platforms are Microsoft Teams and Zooms, but I think as the years progressed, companies have become more familiar with holding their meetings online, obviously, and have become more comfortable with it. And I think the process is now being managed pretty efficiently. In terms of some of the challenges then faced by us as company secretaries, I think the challenge is around taking minutes when at the same time looking at questions that are being posed by people, maybe getting text messages, looking to see who's joined the meeting, organizing IT issues if people leave their mic unmuted, can increase the challenges around the free flow of the meeting and what is happening. And it can be difficult to take minutes and action points at the same time. Also, another challenge can be around hosting the meeting, particularly where you're admitting participants and trying to take minutes and action points at the same time. I suppose this can be helped by appointing someone else to administer the participants who are joining the meeting and also monitor the questions that are being asked. We find that the benefits of a good chairperson are vital to a meeting, be it a chairperson of a large listed company or indeed a small family company. A good chairperson can move the meeting on efficiently and is invaluable to the success of the meeting. This also helps in the accuracy of the minutes and decisions that are taken. We found that it may be helpful for the chairman at the end of a particular agenda item to pose questions or ask for comments or for any issues to be raised on that agenda item at that stage. So a clear minute of what has taken place can be made at that point. Also, maybe a brief summing up of the discussion point by the chairperson can also be helpful to reproducing the essence of the discussion of the in the minutes. I think companies have adapted well to the move to virtual meetings and have the agility to maintain good practices going forward. It is also probably, we've noticed, easier to get hold of directors on the end of the phone now, because when they were in the office, there was more likelihood that they were meeting other colleagues around the office or attending meetings. The challenges outside the meeting, in summary, I suppose there are probably two biggest challenges that we've seen are, one is getting documents executed where there's a requirement to have wetting signatures. Certainly the company's registration office were requiring certain documents that are wetting signatures, and these can be difficult to get organized particularly when you've got deadlines to meet. I know the company's office have moved to a new IT system, which will allow more electronic filing of documents. But this is still bedding in and it has its own teething problems. And then probably the second most commonly mentioned challenge is around that interperson interaction at board meetings and the loss of that boardroom dynamic, particularly around the feel and sense of what's being discussed, where people are physically present in the room. Our conclusions, we've seen probably overall an increase in the workload on company secretaries because of more regularity of meetings, particularly, I suppose, about at the start of the pandemic, where there was a real demand for more up-to-date information about the company, and so there was a requirement for an increased number of board papers and reports to be circulated. I suppose a trade-off here has been there's no travelling really to board meetings now, so directors have more time to spend on issues that actually matter to the company. The main changes we see going forward are probably that there will be more virtual meetings, particularly the out-of-course meeting, which is held between the formal physical quarterly meeting. They'll probably continue the formal quarterly meeting as a physical meeting. And the other change is probably the greater acceptance of electronic signatories, which have been brought upon us more quickly because of the onset of the pandemic. And so there's some of the main changes we've found around virtual board meetings, and I'd now like to highlight some of our experiences and questions we've been asked in relation to the members meeting, the annual general meeting. So moving on, the annual general meeting is the main shareholders meeting, of course, for companies. It's the platform for shareholders to question the board and also raise questions around the annual report and accounts. As the meeting must be held annually in the calendar year, at the outset of the pandemic, there was significant debate over whether companies could or could not hold their AGMs virtually. I mean, for companies that had to hold meetings where there was typically a large attendance of shareholders expected, that would prove to be quite a considerable challenge. And this led to the Companies Miscellaneous Provisions COVID-19 Act, which provided for and allowed for AGMs to be held either as a hybrid meeting or a virtual meeting. This was initially given for an initial period up to the end of December last year. Has been extended to June this year. Of course, single member companies do have the option of passing a written resolution in place of holding their AGM. The preparations around holding that meeting, because of that COVID-19 Act, it has allowed the fully virtual meeting, and those entitled to attend, provided those entitled to attend have a reasonable opportunity to participate. Companies have moved to that form of holding meetings, and we've seen AIB and Bank of Ireland hold their 2020 AGM by conference call with only proxy attendance. But sometimes I suppose those arrangements have had to be changed, and we've seen that in the case of Grafton Group last year, who initially recommended that without a change in the restrictions that shareholders did not attend the meeting due to the risks associated with public gatherings. But they then had to issue an update to this because of the changes to government restrictions, and stating that it would not be possible at all for shareholders to attend the meeting, and it will be a closed meeting with shareholders only being permitted to listen in and voting only by proxy. This proposal actually was challenged by a former chairman of Grafton Group in the High Court. However, the judge ruled that the meeting could go ahead. I suppose this shows the level of uncertainty that persisted at the time around the changes in government restrictions affecting virtual meetings. And therefore, I suppose it might be worth considering in relation to your own AGMs, maybe a look back at what has happened last year, given that we've now had a year of virtual meetings. We can see what worked best for you at your last AGM, what sort of member participation there was, and the format of information you gave to the members, how you provided access, the platform you used for that meeting, and the security around that platform. I mean, obviously, access to the meeting should be as smooth as possible, and oversight of who has accessed the meeting from a security point of view is also of importance. The consequences of not holding a meeting, effectively a member can apply to the Director of Corporate Enforcement to direct the calling of the AGM, and indeed the companies and officers may be liable to an offence. As we've seen in the Grafton case last year, the COVID-19 Act was necessary to allow a greater degree of flexibility around AGMs, and it has enabled directors to cancel a meeting or even change the means of holding the meeting in order to comply with public health guidance. So moving on, in terms of where the AGM can be held, the Constitution is the first port of call to have a look at what that provides for, and there may be specific provisions in there around where general meetings may be held. If the Constitution is silent in that regard, the meeting can be held anywhere. And of course, the COVID-19 Act enables companies to hold their meeting fully virtually, so no physical venue is required. In terms of the notice of your meeting, it's certainly there's probably some additional information that should be inserted in there, such as the electronic platform to be used for the meeting. There should be a date inserted there by which attendees should have to inform the company of their intention to attend, and probably a contact email address for that purpose. If there are any requirements or restrictions that the company has to put in to identify attendees, that should be included, and also how shareholders are going to communicate questions and comments during the meeting, and also probably they should be given an opportunity to ask questions prior to the meeting. The notice probably should also set out a procedure for voting on resolutions to be passed at the meeting. I think we need to be particularly more vigilant around the quorum of meetings, as when they're held virtually, can be easy enough to proceed with the meeting without ensuring that a quorum is present. In terms of nominating someone to attend the meeting on your behalf, as I mentioned in the examples earlier, there's a much greater emphasis on appointing proxies now in light of the government restrictions on public gatherings. So basically this gives a shareholder an opportunity to appoint someone else to attend and speak and vote on their behalf. And in most cases, I suppose people nominate the chairman to do so. I suppose although some companies would probably like to prevent some shareholder from attending their AGM, there's no provision under Irish company law to enable them to do this. However, directors may seek to limit the attendance due to government restrictions. And of course, if somebody's disruptive at the meeting, they may be expelled. In conclusion, the three main issues that we've seen coming out of board meetings and AGMs are, as I've mentioned just now, the difficulties around holding the AGM under the current COVID restrictions. Really, there's no substitute for that face-to-face meeting, because you get that feel and sense of what's going on in the boardroom and can read people more easily. And of course, managing then the signing of documents virtually, where directors are based in different parts of the country, or indeed in different countries themselves. I suppose these will, however, evolve over time as we adapt to this new virtual world. And I hope this has given you a flavour of what others are experiencing. And I'll leave you with my final slide, which shows what most of us feel would be the ideal location for a virtual meeting. And I'll now pass you on to my colleague, Sinead.
Thanks, Alan, and good afternoon, everyone. Today I'm going to be talking about the enactment and extension of the Companies Miscellaneous Provisions COVID-19 Act 2020, giving you an overview of the updates to the Companies Registration Office in terms of the extension of the filing deadline dates, giving you an overview of the launch of the new CRO's electronic filing platform, and then also giving you a brief overview of the new account filing rules for unlimited liability companies. So firstly, I just wanted to talk you through the Companies Miscellaneous Provisions COVID-19 Act 2020. Next slide, please. The enactment of the Act was brought in August 2020, and the aim was to offer, welcome relief to companies and clarity as, they were trying to deal with their company law obligations in the midst of a pandemic. The COVID-19 Act was brought about by virtue of proposals from the Corporate Governance Committee of the Company Law Review Group, and they recommended amendments in relation to the holding of AGMs, the postponement of AGMs, provisions, flexibility in relation to the declaration of dividends, the use of the company seal, and relief and support in relation to companies in relation to winding up and examinerships. The provisions originally applied until the end of 2020, but the government reserved the right to extend those provisions and did so in December, extending them to the 9th of June this year. And as I said, the aim is to offer some practical assistance and a support to companies. Moving on then to look at AGMs. I know Alan has already kind of discussed this, but when you think about it, you know, having to hold your AGM in the midst of lockdowns and health restrictions, it's very difficult to plan for that and to indeed hold your AGM. So given that, you know, the COVID-19 Act gave companies the option to postpone their 2020 AGM until the end of 2020. It also offered clarity in respect to virtual meetings. There had been a lot of kind of debate as to whether you know, virtual meetings were indeed possible under the Companies Act 2014, but the COVID-19 Act offered clarity in relation to that, you know, so long as all shareholders who are entitled to attend would have the reasonable opportunity to do so. Hybrid meetings are also possible under the COVID-19 Act, so that would be a physical meeting where perhaps the chair and a couple of shareholders are located in one location and then others are dialing in. Recognising, you know, rolling lockdowns and how quickly things can change, the date, location and means of holding an AGM can also be amended by giving notice up to close of business the day before. However, I would highlight that written annual general meetings can't avail of any extension period, so they are required to pass their written resolution dealing with the business of the AGM within 9 months of the financial year end, and that only applies to certain companies. Likewise, companies which are regulated by the central bank, you know, they're not relieved of their obligations from filing with the regulator, so just watch out for that also. Next slide, please. In terms of dividends then, you know, recognising that a lot can change in a short space of time during the pandemic, the Act offers flexibility in relation to the declaration of dividends. So if directors, you know, due to, we'll say, an actual or perceived consequence of COVID-19, think that a dividend should be withdrawn or amended, it's possible to do so, but the power is very limited in application and can only be exercised by agreement in writing by all of the shareholders. And notice has to be given no later than 3 days before the general meeting. So taking an example of that, if you say, well, we have a board of directors of a hotel chain, you know, they've met and they've decided that they're going to declare a dividend at their AGM. They issue notice a month in advance of that AGM, and you know, 2 weeks into that notice period, the government's introduced a lockdown. The hotels aren't open. When the directors get, you know, sight of their management accounts, the cash on the balance sheet is not what they thought it would be. And as a result, because of the COVID-19 Act during the interim period, it's possible for the directors to revise and reduce that amount that will be declared, subject to getting shareholder approval and also giving sufficient notice. Moving on then to consider the use of, you know, the company seal and the sealing of documents. Obviously, remote working, you know, has made it very difficult to obtain wet egg signatures and to seal documents. So recognising that during the interim period, it's possible for the company seal to be affixed and the signatures to be sought in counterpart. So taking an example of that, if we take, for instance, a share certificate, that needs to be signed by a director and company secretary. Let's say the company secretary is based in Dublin and she holds the seal, but the director is based in Galway. Well, during the interim period, it's possible for the company secretary to sign and seal the share certificate in Dublin, and for the director in Galway to print a copy of the certificate and sign it. And the two, pages will be counted as one validly executed share certificate. Other considerations that you could consider would be the appointment of a power of attorney, or perhaps looking to amend your constitution so that you only required one signatory with the use of the company seal. Next slide, please. Recognising the financial difficulties and the strain the companies are facing due to the pandemic, the COVID-19 Act has also offered some support. So the death threshold for the beginning of court proceedings for a winding up has been increased from 10 to 50,000 during the interim period, and also recognising the difficulty for examiners to put together a rescue package. The Act allows an examiner to apply for an extension for the period of protection of creditors by an extra 50 days to the court. Moving on then. In summary, the interim period now lasts until the 9th of June 2021. The aim is to provide, support and assistance to companies who are trying to meet their company law obligations, but also to protect viable companies to ensure that, they last the pandemic. Next slide, please. So, moving on then to the company's registration office. Firstly, by way of update, the CRO introduced and announced an extension 2 weeks ago in respect to the filing of annual returns and financial statements. The CRO granted an automatic extension to companies with a 30 September 2020 or later annual return date from filing their 2020 annual return and financial statements until the 28th of May 2021. Previously, an extension was in place until the end of this month, but that was extended out then to May. They also cited that companies with a pre-30 September 2020 ARD who had applied for an extension from the CRO previously as a result of not being able to hold their AGM in 2020 could also avail of that extension to the 28th of May. And that extension applies to companies that have a 30 September or later, 30 September 2020 or later annual return date. Moving on. So just looking at that extension then, from a practical point of view, it means that companies that previously would have been filing their December 2019 financial statements by October or November 2020 now have until the 28th of May 2021 to make those filings without being in breach of their company law obligations or incurring late filing penalties. Looking at the effect of the extension then, in practice, it's interesting because it does offer a window of opportunity in terms of re-registrations of company type and applications for voluntary strike-off. So, I wanted to highlight that previously, if a company was re-registering company type, they would have needed to file that application within 3 months of filing their annual return and financial statements. But because of the extension that's now being afforded, a company which is considering re-registration of company type now would have, we'll say, until August 21 rather than October, November 2020 to use their December 2019 financial statements to make an application for your re-registration. And that would be relevant to you, for instance, if you were considering re-registering from a limited to an unlimited company, in order to make it easier to get profits from a company, out of the company. If you haven't filed those 2019 financial statements, there is a window of opportunity there for you to now re-register. Similarly, in terms of voluntary strike-off, there is an extension being afforded. If you're looking at your group structure chart and you do have certain subsidiaries which maybe are, no longer relevant or no longer of use, now would be a really good time in considering, clearing down those balance sheets and applying for voluntary strike-off for that company in advance of 28 May 2021, because it would allow you to do so without having to file the 2019 financial statements, or indeed prepare 2020 financial statements, so long as you haven't filed those 2019 financial statements already. Moving on then to look at the new CRO's digital transformation project and the new electronic filing platform. The platform was overhauled and introduced in December 2020, and the aim was to streamline the filing of electronic forms, but it also introduced a number of changes that I want to highlight now. So firstly, a 56-day deadline was implemented. So companies, rather than the traditional 2-stage filing deadline process that was there previously, in that companies had to file their annual return within 28 days of their annual return date, and then would have a further 28 days to upload their financial statements and submit their financial statement certificate. That's been overhauled to one filing deadline of 56 days, and the return and the financial statements and any accompanying documentation all needs to be submitted within that window. The other big change is that CRO have reordered the submission process. So CRO now require financial statements to be uploaded prior to the company being able to file its annual return. So that, puts increased pressure on directors and on auditors to finalise and, sign off on approved financial statements and have them ready in good time to allow for the filing of the annual return. Accuracy then has also been flagged as something which is of great importance to the CRO going forward with the new platform. And as a result, CRO have said that they are reviewing the content of the information on annual returns and other statutory forms against the records that they hold on the CRO. And any discrepancies could result in the company's filing being rejected and, an annual return being late and the company incurring late filing penalties. Lastly, as part of the new platform, the CRO introduced an increased number of forms that can be electronically filed. CRO have said that, the reasoning behind this was that, it means greater accuracy and, timeliness of data being updated for companies. Electronic forms should be registered much quicker than paper forms. However, a word of warning for anyone who is electronic filing: be very careful of the documents that you are uploading. Take, for instance, a set of financial statements when you're filing your annual return. If you upload a draft set of financial statements onto the system rather than the finalized financial statements, due to digital constraints, there's a possibility that you can't get those financial statements taken down or amended or rejected. And in that scenario, it could be necessary to go to the courts to have that incorrect submission removed from the register. So just be very careful. Moving on then to kind of look at the new platform and the new rules in practice, I think, an example of coming to file your 2021 annual return is, good to look at. So Previously, you know, if you had a 31 December on financial year end and a 30 September A or D, you would have been filing your annual return on the 28th of October. It was unlikely that CRO would have rejected your annual return on the basis of any discrepancies between their records and the contents of the form, and then you would have had a further 28 days to upload your approved and signed financial statements and, you know, submit your directorship form and the financial statement certificate. However, now with the new system, a successful filing can't be guaranteed if you try to file your annual return on the filing deadline day on the 56th day. Firstly, CRO are comparing the data that's on their files to the data being submitted on the forms. And if there are any discrepancies, the CRO could reject that on your return. So if you take the example of a company that maybe had a capital injection during the year, there was a couple of different service providers involved, and you were told all of the statutory forms associated with it were filed, but you know, when you come to file your annual return on the 56th day, the CRO reject the annual return on the basis that, you know, they don't have one of the new shareholders on their records. Your annual return is now late. You've incurred late filing penalties. You have to scramble to get in touch with the service provider to make sure that the records are rectified and that they're up to date before you can come to file the annual return, try to file it again. And let's say the company was availing of an audit exemption. Well, because the company is now late in filing its return and accounts, the company has lost its audit exemption for the following 2 years. So there can be serious consequences. Remember this year that financial statements also have to be available, ready, approved, signed off before you can upload the annual return and file it. So just be very careful because it will take a little bit of time to make sure that the information on CRO's records versus the information that you are filing you know, is accurate and consistent. So please leave plenty of time within that 56-day deadline period, so as you don't miss your filing deadline. Moving on then, in terms of kind of future considerations with the CRO and, you know, its electronic filing platform, we do see that mandated electronic filing will come into play in the near future because of the benefits of the accuracy of data associated with it and the speed of registration. If you take, for example, the Form B10, that's already mandated to require electronic filing. The Form B10 is in relation to the appointment or resignation or change of details for a director. And you know, how that works in practice is that, let's say, you know, a board meet and they say they're going to appoint a new director in a couple of weeks' time. Well, in that scenario, because of mandated electronic filing, planning needs to go into that change to make sure that the CRO data will be updated in a timely manner and that it will be accurate. So 6 days in advance of the effective date, the Form B10 can be prepared, and only on the effective date can the Form B10 be filed. So in that scenario, you know, it's very important to have your ducks in a row, to have the information to hand so that you can make that filing you know, as close to the effective date as possible. We think that timely filings are going to become more and more important because, you know, the more accurate data is and the quicker that data is registered, the more interested third parties will be in that information. So if you take, for example, you know, a shareholder exiting exiting a company, you know, a third-party bank is perhaps financing that exit. Well, you know, the bank will be looking for an updated printout showing that the forms associated with that exit, such as the redemption of shares, you know, that those are all filed and that the company's filings are up to date and accurate, and a printout is available, you know, as on that date. So we do think that there is going to be, you know, more and more interest from third parties in relation to the data on file with the CRO. Moving on then, lastly, I just wanted to give you an update in relation to the new accounts filing rules for private unlimited liability companies. As with any of these changes, I think the easiest way to explain is always by looking at a group chart. So at the moment, the Irish Holdco Unlimited company there is not required to file financial statements on the basis that it is owned by two individuals, say Alan and Sinead, who have unlimited liability. However, for periods commencing financial periods commencing 1 January 2022, that company will be required to file a set of financial statements on the basis that it is a holding company to two limited subsidiaries, or indeed any holding company which has a limited subsidiary will be required to file. So next slide, please. So looking at that then, you know, what I would recommend in terms of next steps and actions required is that I would recommend you to look at your group structure chart in advance of the 1st of January 2022 to see whether any unlimited companies within your group fall within the enhanced filing rules, and if they do, to consider your filing options for that company and also for the other group companies. So it could mean filing, you know, individual entity accounts or consolidated accounts based on, you know, the company size and thresholds, or, you know, you could look into the option of granting a parental guarantee under Section 357. In the example we just looked at, that holding company will be required to file consolidated financial statements perhaps for the first time. So there is a change there. Finally, when looking at your chart, do ask yourself, you know, are there any benefits in the unlimited company in my group? And if not, would it make sense to perhaps re-register to an unlimited liability company? KPMG, of course, would always be happy to be of assistance to you in the assessment of your group chart or in implementing any changes. But that's just a brief overview of the change that's coming down the tracks. So thank you very much for your time. I hope mine and Alan's presentations were of, you know, relevance and interest to you, and I'll hand you back to Sal now in terms of any questions you may have.
Great, thank you, Alan and Sinead. Some interesting observations and practical examples, some of which I'm sure all of us have come across over the last few months. Alan gave us some insights into the governance of board meetings and the steps companies went through to hold their annual general meetings. Sinead highlighted a rather obvious fact: make sure a document you're putting on public file is 100% accurate, because if it isn't, there's no easy way to correct it. Okay, it's time for questions. There's been quite a few questions during the presentations, which I've attempted to answer during the session. But if I could just kick off maybe with a question to Alan. Alan, in light, I suppose, of the continuing COVID-19 restrictions, what do you see as the main concerns facing boards over the next 9 months?
Yeah, I suppose probably one of the principal concerns is around that interaction between directors and their senior management or executives. You know, it's difficult to develop those relationships. We can remember when we used to be in the physical room, and, you know, that opportunity at the end of the meeting to have a chat on a one-to-one basis over maybe a particular issue during the meeting, or indeed just to have a casual conversation to get to know somebody better. So I suppose that's one of the challenges there. And then, of course, there's the unpredictability of the environment we're in at the moment. You know, will there be more lockdowns? You know, the challenges around that, and how companies are going to operate in this unpredictable world we're in at the moment. Uncertainty around profitability of companies, and you know, trying to plan just really for the year ahead, and in terms of where we are.
Okay, great. And just Sinead, I suppose what's been the feedback of users of the new CRO filing system so far?
Like any new IT system which is being introduced, there are teething issues, there are bugs, but the CRO is definitely working to fix those bugs. And in recognition of, you know, the challenges of the pandemic, but also the introduction of the new e-filing system, the CRO have granted that extension to companies to have until, you know, May to make the filings. So there's a bit of time to get to grips with the system. But, you know, I think ultimately we will see the benefits of the system down the line, in that a company's records will be, you know, more accurate, it'll be more up to date. And, you know, moving towards mandatory electronic filing is only a good thing, because it does cut down as well on, you know, the administrative burden for companies. Like previously, it was, you know, it was necessary to get wet ink signatures, which meant, you know, directors and secretaries printing documents, signing them, and then organising for those originally signed forms to be posted or, you know, brought to the CRO. Whereas now, you know, that form can be printed, it can be signed, scanned, and uploaded in a matter of minutes. So, you know, from an administrative practice, it should be easier as well. It's just everyone getting their head around the changes.
Sure. And just saying, just a question that's come in there. There are some issues around paying for lodgements at the minute, a practical issue around that.
Yeah, I think there has been issues with kind of service platforms like Blueprint or AGMs, and them linking, you know, the payment of forms through their systems. So there has been some extra steps to have to go onto the CRO site to pay for submissions. But you know, CRO are aware of these bugs, and they are working to fix them, and there has been a couple of bugs which have already been resolved. So I have no doubt that people will get to grips with things, but yeah, it just takes a little time and patience.
Yeah, it's not going to happen overnight. Sinead, just one last question maybe to you. After the pandemic, do you think the provisions of the COVID-19 Act will be fully incorporated into Irish law, rather than at the minute it's just during the interim period?
Yeah, I think that's an interesting question. Like, from talking to you, Sal, and, you know, the kind of insights into the company law review group, I think holding AGMs virtually, and whether it was possible to do so, was a very kind of heated or contentious, you know, issue. And I think, you know, it would be reasonable to expect that, you know, that issue would be on the work programme of the company law review group going forward. You know, and it would be reasonable that it would be provided, but obviously I can't speak for the company law review group. But, you know, thinking about the future, and, you know, the kind of hope for virtual meetings from a practical point of view in terms of travel restrictions and, you know, remote working, you would hope that it will be possible that virtual AGMs will be extended into the future post-pandemic.
And I'd agree with you. Hopefully that will be the case. It's kind of, everyone's had to take a massive jump with the virtual bit in the last 10 months or so. So hopefully that will be the case. Alan, if I could bring you back in for a minute, just do directors believe they've been kept well informed of key issues on a timely basis during the pandemic?
Yeah, well, as I mentioned in my presentation, I think there's certainly more regularity we've come across with meetings generally. So there's been a greater demand to get information, up-to-date information, out to directors. So I think in general they are better or well informed of the issues, and are on top of sort of the the real fundamental issues around control and financial data that they wanted to get hold of in light of, naturally there being a pandemic. Those issues are very fundamental to get up-to-date knowledge on those issues. So I think, in terms of information getting out to them and more regular information, I'd say that's probably as good as it ever was.
Okay, great. Great. Okay, well, there's no new questions coming in, so I'm just conscious of time, so I'm just going to wrap up. A huge thanks to both our speakers, Alan and Sinead. I hope you have enjoyed their insight. Also, these events don't happen without an awful lot of work being done in the background, so a particular thank you to the KPMG marketing team, particularly Sarah Higgins and also to Grania Smith on our team. As I mentioned, we'll be sharing a recording of the event with everyone, so look out for that. And once again, thank you for taking part today. All the best.